Hello everyone, this is Jackie Jones and this is the second module of the first lecture in family law practice, and this lecture is going to be about parenting. In the first module I talked about parenting being contained in Part 7 of the Family Law Act. So it's very important that if you do have a parenting matter, you do go to that section and you find the relevant parts that might be important for the particular issue that your client is facing. Family law was subject to significant amendments back in 2006 to the Family Law Act under the Howard government, and I've got there on slide 3 the intention, and what was very important was the introduction of mandatory mediation. I've got an acronym there, FDRP. What that stands for is a family dispute resolution practitioner. So what is required to happen now is that if there is a parenting issue between separating couples, before they can file an application for parenting orders in the court, they must go to mandatory mediation with a family dispute resolution practitioner. Now, there are exceptions to the mandatory mediation, and that relates to whether there is violence that is existing or alleged to exist between the parties, or alternatively, if it is a matter of urgency. So, for example, if someone came in to see you and said that they were concerned that the other parent was going to take their child outside the jurisdiction of Australia, namely that they were going overseas or even interstate, and it was without that parent's consent, that would be an urgent matter. So you would be able to file an application to get before the court and not have to go through the mandatory mediation before such an application is filed. In practice, the mandatory mediation has worked quite effectively. So parties having an issue as to pick off time, pick off venues, Christmas holiday periods, Christmas Day, birthdays, matters that otherwise had clogged the system, are dealt with quite effectively by a family dispute resolution practitioner, with the focus always being on children. Now, language in parenting matters has had an evolution since 1996. I'm sure that you're probably all still familiar with the term custody, access and guardianship. In fact, even now people talk about the custody of children, and that's a word that hasn't been in the Family Law Act since 1996. Between 1996 and the amendments in 2006, the terms were residence, where a child resides. So a child will reside with whichever parent and then have contact with and define the periods of contact with the other parent. And the word that replaced and, well, in fact changed the concept of guardianship became parental responsibility. The correct term now is that a child will live with a parent. I mean, they might live with a parent one week and live with a parent an alternate week. They might live with a parent from Monday to Friday and live with a parent from Friday night to Monday morning. I mean, there's lots of different ways of how children move between their parents. They might have the expression that a child lives with one parent and spends time with another parent. We still have the overarching responsibility of children called parental responsibility, which I'm going to talk about in a moment. Very important key words for you to understand and appreciate, and that is equal shared parental responsibility, linking in with the overall parental responsibility, and the best interests of the child, which is the paramount consideration in all parent matters. So slide 5 talks about parental responsibility, and it gives a number of relevant sections in the Family Law Act. It defines it in section 61B. It's the overarching legal basis that parents have in relation to their children. And subject to a parenting order, both parents of a child have that parental responsibility of a child until they're 18 years of age. And of course, once they're 18, a child then is deemed an adult. Decisions that are covered by parental responsibility. Well, in practice, we focus on Section 4 of the Family Law Act, which talks about major long-term issues, and they are education, health, the name of the child, the religious and cultural upbringing of the child. Now, they're as you might like to think of them, the big ticket items. So by having joint parental responsibility means that both parents need to make a decision about where a child or the children are going to be educated. In practice, that can be a very challenging aspect for parents, particularly if there are competing religions. One person might want to send their child to a Christian school in the sense of a Protestant school. Another parent might want to send their child to a Catholic school. There may be a parent who wants their child sent to a non-denominational school so that there be no religious affiliation at all. Certainly in my experience, and I've run a number of cases whereby the court has had to make a decision as to which school the child is going to go to. One of the cases that I remember clearly is that it was a very long case, taking from go to woe. The first determination from an appeal point was 6 years. And one of the interim matters was the school the little girl was going to start at. The mother bought uniforms and enrolled the child at a school in Victoria. The father bought uniforms, enrolled the child in a school in Sydney. This child had photographs taken of his respective school uniforms, introduced to friends at the respective schools. So you can imagine the dilemma and the lack of focus on the best interests of the child that the court picked up on in that regard. That child at that stage was spending 1 week in Victoria and 1 week in Sydney between the two parents. So we have a presumption of equal shared parental responsibility, and that is very important. Particularly when you feed into Section 65D, capital A, capital A. And if it is the case that parents are to have the equal shared parental responsibility, then the court must, and it is a must under the legislative guidelines, consider what is set out in that Section 65D AA. Section D AA. And that equates to equal time. And that may be where a lot of people are getting confused. I've certainly had clients come into my office saying, well, I want equal time. I'm entitled to equal time. I've told that I've got equal responsibility, equal time. Now, the court is required to make a consideration whether equal time is appropriate if parties are to have equal shared parental responsibility. Even if parents have equal shared parental responsibility, the court must first of all determine is equal time, first of all in the best interests of the child, secondly is it reasonably practicable, and if it is not equal time, should it then be substantial and significant time. So in the case I was just referring to, the first trial judge determined that the parents should have equal shared parental responsibility, and made an order that the children were to live in Sydney with a week about between the parents, notwithstanding that the mother's evidence was and case was that she wanted to remain in Victoria. And on appeal, one of the issues that was raised was that the court didn't appropriately consider whether it was reasonably practicable for the children to have equal time between their parents, given the mother's stance on not wanting to come in Sydney. There are situations where there is no presumption of equal shared parental responsibility, and those are detailed on slide 8. As I stated, the overriding philosophy with regard to parenting matters is that the best interests of the child is the paramount consideration. And a bit of just a point for you in family law matters, what your client considers as the best interests of a child isn't necessarily what the court is going to consider. With a parenting matter, I would not draft an affidavit, orders to be put into an application without opening section 60cc and looking at the factors that the court considers when addressing what is in the best interests of a child. What are they required from a legislative direction to consider in addressing that determination? So it's important for you to be mindful that equal shared parental responsibility does not equal shared care, i.e. it does not equate to equal time, but the court does have an obligation to look at all the relevant factors. It's not uncommon that people say there are presumptions in the family court system, but from my perception, certainly the law is that there is no presumption in favour of mothers in favour of equal time, or that all parents have a right to spend time and communicate with the children. The objects of the Family Law Act do give children a right to have a meaningful relationship with both parents, but that is always still subject to the best interests analysis. And it is very difficult. Parenting is a challenging area in the family law arena, and certainly one that is inevitably fueled with emotion. But what's violence got to do, and how does it impact in family law matters? And I'm sure that you're all aware of the violence as a topic of conversation in the social media outlet, and you'll be aware of numerous cases, including the father that threw his daughter off the bridge in Victoria, or the Luke Batty case, who was killed by his father with a cricket bat. Violence is an important factor, and it's one that the court, I think, is mindful of, but is still always struggling to deal with. There is a notice of a child abuse form that is required to be filed, but there are different rules in the family court than the Federal Circuit Court, so it must be filed in the Federal Circuit Court in any parenting matter. In the family court, the notice of child abuse is only filed if in fact there is going to be an allegation. There are best practice principles now for use in parenting disputes when violence is alleged, and this could be a topic all on its own for a lecture, and so really all I'm doing is touch pointing areas for your consideration, and that if you wanted to do some research on if this was a particular area of interest to you, you could do so, including having a look at the Family Courts Magellan program. Slide 12 talks about some of the challenges that really are faced when violence is part of that family dynamic. The role of the social science, for example, the research and the literature, the right of a child to be protected from harm is in fact the greatest weight in comparison to other objects. So there's a lot of tensions that happen in working out, well, how do we actually deal with this in a meaningful way, but always having the children as the paramount view and focus. There are a number of professionals that come in to assist the court and the lawyers in parenting matters. A family consultant who will prepare a report, meet the parents, interview the children, be part of the less adversarial trial process, and assist the court in their findings as to the family dynamics. In cases where it is warranted, there may be other experts such as a psychiatrist who will meet the family, often on more than one occasion, to prepare a report, again with the view to assisting the court as to how to deal with the conflicting and competing parenting orders that are being sought. And finally, another way the court is assisted in parenting matters is through what's called an independent children's lawyer. And slide 14 gives you just some information on an independent children's lawyer. There was a case decided a number of years ago now that sets out the guidelines of when an ICL is to be appointed. One of the interesting things about an ICL is that they're not bound by the instructions of the child. And so a child may be articulate and form a view and relay that to the independent children's lawyer, but that may not necessarily be the submission that the ICL makes to the court, even though the ICL is bound to at least tell the court the child's instructions. There's been some controversy as to some ICLs in some jurisdictions throughout Australia not meeting children. And certainly there's been a view expressed as to how this could be improved, and the communication between the child and their representative in this court process can assist the children in feeling that they do have a voice in the court system. And again, this is another area that could have a lecture on its own, namely the voice of a child and how does a child actually express its views through the court system, given that the child is often the focus of the competing orders sought in applications. So just a bit of just a touchstone on parenting, just gives you a brief outline, and the next module for this lecture is going to be having a touchstone on financial matters. Thank you.